Welcome to Employment Law This Week. I'm George Whipple. 2023 was a big year for trade secret and non-compete law, full of enforcement actions and rulemaking on the federal level and legislation in the states. Spilling Secrets, Epstein Becker Green's podcast series about trade secrets and non-compete law, has been there through it all. This week, the team presents their lineup of the top 10 developments in 2023. Here are some of the highlights from their discussion, and you can check out the full Spilling Secrets podcast for the complete top 10. First up, Epstein Becker Green's Kate Rigby digs into federal action. In 2023, the SEC continued to focus on non-disclosure agreements and other confidential provisions, ensuring whistleblowers are not restricted from freely communicating with the SEC. We saw similar action from the NLRB.
In the McLaren-McComb decision, the NLRB found it unlawful for an employer to proffer a severance agreement with broad non-disparagement, but also confidentiality provisions. And in the board's view, these type of provisions can infringe on an employee's rights to discuss things like wages, working conditions, et cetera, with others. And the language specifically at issue in this case, the confidentiality provision, was not all that special, really, and it wasn't really all that controversial in and of itself. But it was noteworthy that the provision at issue included none of the carve-outs that have really been best practice for quite a while.
On the enforcement side, the NLRB's general counsel released a memo stating that non-compete clauses violate federal labor law. Shortly thereafter, the NLRB brought an enforcement action against a Michigan-based company, followed by another in Ohio. Epstein Becker Green's Millie Warner tells us what that signals.
It's become quite clear that the NLRB does intend to act fairly aggressively when it comes to post-employment restrictive covenants that it deems to have a chilling effect on employees engaging in Section 7 activity.
The FTC got involved this year, too, for the first time in its history. The agency proposed a nationwide ban on post-employment non-competes. A final rule is expected in April of next year, but legal challenges are certain to follow. That sets up 2024 to be another big year for non-competes at the federal level. At a state level, California expanded its non-compete ban effective January 1st, 2024. And Minnesota made non-compete history in 2023. Epstein Becker Green's Pete Steinmeyer tells us more.
Minnesota is the first state to ban non-competes in over 100 years, and it has become only the fourth state to do so. The others are California, Oklahoma, and North Dakota. The only exceptions to the ban are non-competes in agreements relating to the sale or dissolution of a business.
In New York, Governor Kathy Hochul recently suggested she would not sign New York's new non-compete legislation, which passed the legislature this summer without exceptions for the sale or dissolution of a business and changes exempting high earners. She has indicated that she is working on a compromise with the bill's sponsors. This is a developing story we'll keep an eye on. Cheers to the Spilling Secrets team for another year full of important information for employers across the country. We can't wait for more next year. Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.